So welcome back to the Big Small Business Show. And if you missed our intro, we are with Marto. He is who are you? You're director. I thought you were the managing director. You're the director of Marto Lafitte and Associates. And we've been talking all things legal today in today's show. We've just spoken about which entity you should be trading as, whether it's a trust, a company, a partnership, or a sole shareholder. And now we're going to be talking about limiting liabilities. There's 5 different methods we can use to limit our liability, to protect ourselves, so to speak. You spoke about piercing the corporate veil. Just before we even start, what does that mean?
So when you create a company, when you register a company, then the assets and liabilities of the company are that of the company. So there's a separation between the assets and liabilities of the shareholders and those of the company. So that we call corporate veil.
Right.
And that's what protects you. So this topic is really about risk management.
Right.
And the first way to manage that risk and most effective is by registering a company to provide you with that corporate veil. And that way, it will go a long way in terms of protecting your personal assets from any liabilities that the company may have. We spoke about those exceptions, which we won't repeat, but for the most part, the corporate veil protects you as a shareholder going into business.
Okay. Number 2 is the corporate structure.
Number 2, corporate structuring. So in this regard, you can structure in such a way. Let me give you an example. If you are in manufacturing, you could structure your company whereby you have one entity in which holds all your assets, and you have a second entity, second company, which you run the business from in terms of a trading. Mm-hmm. You can then lease your assets from your asset holding company to your operations company. If things don't go well, then at least the trading company may go insolvent, but your assets are still protected. So through intelligent and strategic corporate structuring, you can also limit then your liability and risk.
And that's often done with property, what they call propcos, right?
Correct.
So opco and propco.
Correct.
So, right. The operational company sits in there, and then the building is not owned by the company; it's in a separate company.
Well, my legal practice, I have a property-owning company where I operate the business from. If for any reason I no longer practice, or if my practice runs poorly, then at least it doesn't affect the property-owning company and the property that I'm in.
And the downside, of course, is the additional expenses associated with audits or the accounting side of that.
But look, these days those are negligible. Especially with a property-owning company, you probably have a handful of entries per month. So it really the benefits certainly outweigh whatever those costs are.
So that's now the corporate structuring. Estate planning.
So estate planning, again, I'm told by tax experts that ideally we should have little to nothing in our own name.
Yes.
And that in terms of estate planning through the structuring with a trust planning, one could structure your estate in terms of being able to avoid estate duty on one's death, and also in terms of limiting one's liability in respect of corporate structuring, which we've spoken about already. So it's just extending the corporate structure protections to your personal assets as well.
Okay. So just come back to the trust, and I know that we're talking about limiting liability, but on the trust side, there is also a view now that trusts are becoming more and more like companies, that there's less and less protection in them from a tax perspective. Is that true?
I think if you structure it properly, there's still definitely a place for trusts. Like I said in the earlier segment, I advise against putting assets directly into trusts and operating businesses out of trusts. So we create silos of protection. So if you are an entrepreneur with various businesses, you may have more than one trust company structure, but you want to be operating the ops side, you want to be doing through a company with the shares of which can be held by a trust. And that is the Rolls-Royce model.
Okay. Estate planning, we've spoken about that. That was then insurance.
Of course, that's what it's there for. So we should consider always various types of insurance when opening a business. Public liability is an obvious one. The type of slip and fall cases, someone slips on your premises, you don't want to be taken out because of an accident. But over and above that, something like professional indemnity insurance, so that you're covered, and that if something does happen, that at least you've got an insurance umbrella and safety net to be able to assist you in those circumstances.
What I've seen happen now quite a lot in that space is fraud insurance.
Yes.
Because fraud is becoming so prolific right now. There is an insurance class around fraud,
and especially cyber fraud.
Yeah.
That has gone through the roof. And for example, attorneys are targeted in terms of phishing schemes, etc. So it's very important to be able to see which areas of my business are vulnerable and which insurance I can obtain in order to cover that risk.
And then the last one we can talk about now is contractual limitation.
Yeah, so in business, of course, you can put that as a term of contract. So with my customer, I can say I'm going to provide you the service or sell you these goods, but I'm limiting my liability to, for example, only gross negligence or in respect of certain categories of negligence. So one can still do it contractually and bring down that risk of liability once more.
I just want to talk about something that I've heard about happening. I've never personally experienced it, about people selling businesses and not contracting away from the liability into the new entity. In other words, they still are sued post-selling because somehow they are still liable for what goes on in that business. Is that a rumor? Is that possible?
It would only be possible if, for example, you reserve ownership of your shareholding until the full purchase price is paid. So you still are the owner, even though you've now sold the business onwards. So what would happen is that inter partes, so between a buyer and a seller, that purchaser accepts liability. But in relation to the public at large, that might not be the case. And so they'll still look potentially to you. Of course, there's still ways of resolving that. If you'd advertise in terms of the Insolvency Act, it should prevent that. So there are protections that you can do not to be caught in that situation.
Roy, that's all we've got time for this segment. Please stay tuned. When we come back, we're going to have one more legal lesson from Roy Marto, and it's all to do with e-commerce. So that's a very scary place if you don't understand the legal frameworks. Stay tuned.